I think they have entered into complete bargaining, and that he didn't pay fully per the time given him. And in the desire of the Attorney General, they were not minded to give him extra time to pay. So I think that is the choice of the Attorney General for the criminal proceedings.
And is it a good choice for the country? Is that in the national interest?
Well, I think if we are minded to retrieve our money, somebody going to prison will not work and get money to pay. So that defeats the desire to retrieve money. But in order to show the person that you have committed crime against the Republic and that the Republic is not happy about your behavior and they want to teach you some lessons, then you need to go to prison. I think that these are the two choices left to the Attorney General, and he has chosen the one for him to go to prison. But I think we need to look at all these things largely in the propriety of the banking sector cleanup, and then for the government to claim that there is one casualty in prison custody who have been convicted because of a crime, and that perhaps the crime that was convicted is a justifiable reason for the collapse of those banks. And this is where we need to draw the line. The bank did not commit any crime. The bank is established having legal rights by its artificial being, which is expected that officers employed by the bank and including regulated are supposed to act to protect the bank. So if an officer has done something against the bank, I'm not sure that the punishment goes against the bank. So I think the collapse of the bank is actually a reckless activity. It didn't inure to the benefit of the economy. If you pursue criminal proceedings against Ato Essien, while other people take charge of the bank would have been in business employing thousands of people today. So the choice of collapse of the bank cannot be linked to the prosecution. The prosecution is a different matter that has nothing to do with the choice of the collapse of the bank.
So clearly for you, jailing him cannot be a justification for closing the bank. You still insist that it was a reckless act.
Yes, it is not. And we have showcased what I'm discussing. I think you knew that 5 banks were having problems. And the government of Ghana decided that I want to save those banks. And those banks were having similar challenges that this bank was having. But they decided to save them up to date. In fact, some of them were not performing well, even under the vehicle they put them under. So there is no justification for collapse of the bank. You collapse banks in a very, very, very tight situation, and we have not gotten to that tight situation.
So we were not in that situation before the banks went down.
I think this bank, I keep on saying that this banking sector cleanup actually is a candidate for widespread, comprehensive investigation by the state at a point in time in the future. Because if you know the history of the banking sector, in 2014, the banking sector was identified to be having a problem. And the problem are different. Some because of the corporate governance issues, some because of weak oversight by the regulator, some because of some of the things that even the owners and directors were doing. Some of them is just a manifestation of the nature of the economy. So an investigation was conducted. In fact, audit was conducted because at that time they were thinking that some auditors were not auditing the accounts well. So they even changed auditors to go into. So if you're auditing a bank A, they allow audit firm B to come in to audit you instead of the original auditor. For that was done, and a report was written. And one of the critical measures to be taken was not contained efficiently in the existing act. So the decision was taken that we needed to put in a new act so that we can use that act to do what we want to do. And that was why at 9:30 was actually sponsored by the IMF, World Bank. In fact, when they finished, they needed to have interaction with the banks, CEOs, boards, and the rest, and which was done to understand the act. And I remember, I attended one of that meeting, and I remember that some CEOs raised issues, but those issues were as critical as they were. The act was passed already. For that act to be used to deal with the situation. So it's not as though that the country was not aware of the problem. And then one critical problem was the 2015 Act that deals with energy sector levies. That act was also another solution to the problem. So the problem was known, and the solution was very clear. So that was put in place so that money will accumulate 2 years or 3 years. Then that will be used to amortize the loans for the IPPs, and the IPP will in turn pay the banks, and the bank liquidity will improve, and that will also improve the capital base. Because you see, if somebody wants to collapse a bank, it's very easy from regulatory point of view. It's just a matter of refusal to pay. Debt or individuals who also owe the bank. So for the government to take decision that they will not pay contractors or selective payments to contractors, that is one of the reasons why we find the situation we are discussing today. So government is a huge contributing factor to the difficulties the banks have actually exhibited. So I am clear in my mind that the approach that was used was not the approach that is needed to clean up or to reform the banking sector. It was an approach that actually enhanced the difficulty of the banking sector, and a further action taken to collapse them in a manner that was done.
Okay, so then having said that, there are people were raising questions. In fact, Lawyer Martin Pebu is one of those being reported that he feels that Mr. Essien should not have gone in alone if that's the choice the government has made, that it should also affect the board, the governance board of the bank. What do you think?
Well, let me tell you how the boardroom operates. Now, first of all, we need to appreciate that the board is not the operational managers of the bank. We have management of the bank led by the CEO. And most of the things that are done will be done by the CEO. The board operates when they go to the board meeting. And when documents are presented to them, they review the document, ask questions, and take action. That is how boards operate. Now, and then in the banking sector, the Act makes the internal audit and the finance very, very powerful. And that is the reason why it is the audit section of the bank, internal audit, is supposed to report directly to the board, because they will be giving what is going on to the board. So the board takes decisions. Now, if indeed some investigation was done into the bank, then all these things would have been disclosed, where the board chairman will have to sign certain things for it before it occurs, and where the entire board will have to take a certain decision before it occurs. All these things will be known. So if the prosecution choose not to prosecute those people, I don't know what incentive they will have today to go and prosecute them. Because they have, if indeed the board chairman, including the board members, have done something wrong, they would have known all those things from the onset and took the decision, this thing we want to deal with. I believe that was what happened. So I don't know what incentive the state will have today to say that I'm going to prosecute board chairman, I'm going to... and remember, we are talking about crime. As to whether what Essien did was known to the board as a whole, or was known to him and the chairman, it is something that has to be revealed for us to... But you can't be outside and be conjecturing that, okay, since Essien was punished, then the whole board or certain people on the board should be punished. No, it doesn't work like that, because something may be happening between the board chairman and the CEO. Other board members will not be aware unless those matters are brought to their attention for discussion, because the structure of the board is such that if the internal audit doesn't see it and report for them to take action, external auditors are supposed to see it, or the regulator is supposed to see it. Because you see, when the regulators come to investigate, to monitor, to do all manner of things, and then the final report or the financial statement of the bank is supposed to be sanctioned by the regulator before it can be published. So all these things are there. So for anybody to think that the board as a whole would have involved in these things, the person may be mistaken, unless the dossier that led to Essien prosecution and conviction indicates from onset that this transfer that Essien made, it was countersigned by the board chairman. So the board chairman is aware, or it was brought to the board meeting, and they took a collective decision that this money, which was taken from Bank of Ghana, which was actually a loan, that the bank has taken to pay interest of the policy rate at that time, they have taken decisions that this money should be distributed into this company, that company, and this company. It is only then that we can say that there are other people who have to be prosecuted for that. But I don't have that impression unless the prosecution document states so. And this would have been done from the onset.
Like it's famously said in a courtroom, criminal prosecutions are based on facts.
Yeah.
And you believe that the government is fully aware of the facts of the case and they chose this part. So that means that they perhaps they believe that there was no case for the board chairman to answer. That's all possibilities.
I cannot say, because you see, prosecuting people based on these facts depends on the desire of the prosecutor, those who are prosecuting. What do they want to achieve? Do they want to protect somebody? What was the evidence in the, in the prosecution? Did the evidence say that Ato Essien transfer the money they took from Bank of Ghana to further or to strengthen the bank was diverted to this, this bank or this company or that company, which was discussed at the board meeting, was captured in the board minutes, or it was something that was done by him alone, or which he didn't disclose to the board members, or was it the case that it was disclosed to only some members on the board, especially the one who could countersign some of the documents, and then they didn't bring the matter to the board to discuss. So these are all the issues. And then again, what role did the internal audit play? Did the internal audit not see that? Is there any record to show that internal audit has seen it and they have shielded it or they have reported to somebody? And who is that somebody? Because the internal audit is subject to the board. It's not subject, in practical terms, it's not subject to the chief executive. It's subject to the board. Have they presented a document of that nature to the board and the board looked at and pass it or not pass it? Or it was sent to the board chairman and the board chairman didn't table those things for discussion by the entire board and the decision taken between him and the chief executive. Then we go to the external auditor. Did they see or did they not see? Then we go to the regulator, because any bank's financial statement will have to be approved by the regulator before it is published. So, did the regulator see that or not? And when they saw it, what action did they take? So these are all the things that we should do. But it's not just about somebody is a board chairman, therefore he needs to be prosecuted. The facts must show, because you see the person is not in the board in the company on daily basis. He comes as and when standard reports are presented to him, and he looks at. He led his team to look at it. They question, they get answers. They get answers and match the answers with the regulations governing the bank. Look at the answers, and then look at the Bank of Ghana rules, etc. So, these are the things that I know. So it's not a matter of when one person is prosecuted, then the rest should be prosecuted. The facts must speak to it. And we also have to be careful not to empower the state to do something fishy. Because as soon as people started calling for the the prosecution of other board members and the rest, then I overheard the Deputy Attorney General started warning people that the rest should not think that they cannot come after them. And that sounds very funny. So we shouldn't use this thing to just empower or weaponize the Attorney General to start doing something fishy. They should have known those people who are culpable at the time of prosecution of Essien, and why they didn't start prosecuting them or not is a matter of public interest.
Okay. So should we be asking for the facts of the investigations, at least the report of the investigations into the Capital Bank matter?
Yeah, this is a public interest case. Of course, Capital Bank did not take any money from the Republic as it is. It took, of course, Bank of Ghana is a state institution. It took money from Bank of Ghana, and the state will have to prosecute. So that becomes a purely public matter. So the fact you adduce should be known. What triggered the prosecution of Essien should be known to the public, and whether or not other people were part of your documentation, but you choose to prosecute Essien. And this period, nobody should be telling me that it's a strategy, or we decided to deal with Essien before we come. No, nobody should be telling me that thing, because if you know that 10 people are involved or 3 people are involved, those are the people you should prosecute to court.
And even in the face of this, Dr. GATSI, Prof. GATSI is still insistent that the banking sector cleanup was unnecessary. It was a reckless move.
Oh, yes. Oh, yes. and because we know, for you to collapse a bank, you must think of so many things. And that so many things call for principle-based approach to banking sector cleanup. Those considerations lead to protection of jobs. Those considerations lead to the existence of the bank. Those considerations lead to the care for the economy. Because you can't tell me that you have cleaned up a banking sector that you have earmarked to spend 9 billion, but that you end up spending 25 billion. And all the problem of the banks in terms of capital, is not up to 10 billion at the time that this thing happened. And you can't tell me that you can collapse a bank because of criminal activities. We have seen it in Canada, we have seen it in US, that even banks were taken from families and given to people, to other people to manage because of all these considerations. So it's not that we have not seen it in the world. It's not that we have not seen it. And you ask yourself, which one will be more beneficial to the economy?
Prof,